So one of the things that I think is most commonly overlooked in a contract is the boilerplate. People will spend an appropriate amount of time negotiating the important deal points, financial terms, and so forth. But they won't pay attention to what they call the so-called boilerplate. And much of the boilerplate is truly irrelevant and is there as a stopgap because if something happens, it's important that it's there, but it doesn't need to be negotiated. But the attorney's fees and cost provision is a really important boilerplate term to look at, and often buried within that is a jurisdictional selection clause, and that should be looked at, or sometimes they're separate clauses. And it seems to me that this is something where when you're negotiating a contract in a country, you ought to engage really qualified counsel in that country to help you be aware of the jurisdiction selection clauses and the attorney's fees and cost clauses, and perhaps other things if it's going to be under American law, the possibility of jury trial waiver, the desirability of arbitration or some other ADR instead of the court system. These are things that should be thought through as carefully as the financial terms of the agreement.
Yeah, and I think in addition to that, you often see that you have problems enforcing any award in an arbitration, or if you have litigation, that you can actually not enforce a judgment. This is because Denmark do only recognize other EU judgments, but not US judgments. So if you actually get a judgment in the US, you cannot just necessarily enforce it, so you need to think about that in advance. If you go to arbitration and you actually phrase your arbitration clause in the correct way, you can actually enforce an arbitration award. Another thing which is very, very important is, apart from all the boilerplate issues and the procedural issues, you actually need to think about the merit of the contract, because the whole content of a contract can actually change if you have a jurisdiction clause, for example, dictating Texan law. Texan law is not necessarily the same as Californian law, and is for sure not the same as Danish law. So the whole content of the contract will actually change if you change the jurisdictional clause. This is very often overseen by Danish companies, and it is so fundamental, so it's really one of the first things you have to think about.